shall stand extended till the next date of listing.
Oblige, your lordship.
Mhm. Okay.
Sir, you intend to continue?
Interim will continue till the next date of listing.
May I please, your lordship?
What? Really?
No, but you intend to continue.
Don't worry, don't worry. Interim in, there's interim in what? Charge sheeted one also?
No,
No.
that is the first.
The interim bail granted in Dibrugarh PS case number 193 of 24. Let's be specific.
Fine.
Shall stand extended till the next date of listing.
Fine.
No worries. No worries.
May I please, your lordship?
Yes.
I beg to mention one interlocutory application for correction of order, lordship.
Okay.
Here is some
Okay.
typographical.
You want to list it today?
Today, lordship.
Bring it
Hello.
for correction.
Number one.
May it please your lordship. Lordship is a 483 bail application, lordship. Lordship is in custody for the past 1 month, 23 days, lordship. 53 days as on today. He was booked under section 59 in the section 12 of the Port Trade lordship. Lordship,
Also,
so at this stage,
diary.
this may be issued
Okay.
and case diary may be called.
Okay. J. Singh Po,
No, AK Choppy,
AK Chop. Your good name?
AK Choppy.
Okay. Learned Counsel and additional P. Botagu. Is to call for the case diary of Sapatgram, it's called.
Yes, sir.
Sapatgram. So Sapatgram PS case number 58 of 2028. The section so and so. Also, steps of notice may be taken upon the respondent number 2/informant to the office of the learned public prosecutor and to be executed through the concerned police station. Sapatgram PS within bracket in the district of Dhubri within bracket. That will be clear. In case of any doubt, list the matter on
11/12.
Lordship shorter day may be given because on
Today is my lord 53 days, so I am
53 days, so-
calculating that date on 10th day, my lord,
on s-
11/60.
before 8.
that cannot be bad for you. I mean,
On 8 lordship, because on 9th, his mandatory period will be.
his
Earlier rejected by your lordship.
earlier rejected. So anyway, don't you think it would be better if it's a 60-day offense if the investigation is not completed?
Yes,
Usually it is completed in POXO cases.
yes.
If it is not completed, you will get, so it is best to, today is 53 days.
Yes,
It
sir.
is best to fix it on the 61st day. And in that case, if it's not charge sheeted, you straight away get the bail. That's best. When is the 61st day? 11th. That's why you were suggesting. Is it okay? Or you insist on 8?
If it's possible on 8,
8.
much obliged.
I don't know what to, I mean, 8, my lord, difficulty is that if I again, my lord, CD send back, then the
Yes, yes.
IO cannot, it would be difficult for him to find.
Yes, that is why we said, that she was insisting.
On, that's why I'm fixing it, paying for on 11, 12.
Because we have to give full time to the IO to investigate actually. Anyway, as per her wish.
Yes.
As per her wish.
May I please-
Just a minute. Just a minute. Yeah, tell me.
In item number 10, I am mentioning maybe password for time being.
Yes, I was also thinking, let us finish the other matters, other bail matters.
Yes, ma'am.
Then we can
Thank you.
touch this. Item 3.
Time.
After some time.
May I please, your lordship?
Yeah.
Regular bail application.
Yes, yes.
Accused persons are behind the but from the last 27 days.
Case diary received, my lord.
FIR case number 20. ma'am.
Yes.
FIR was lodged by one of the student union leader, madam. 5 copy of page number 20. ma'am. May I refer?
Nasty allegations, huh? I mean, nothing to with the religion and all, but these are all misplaced beliefs.
Actually, my lord, accused persons 1 and 2.
Mm.
They were not present at the place of occurrence. They were inside the hospital. The the son of the accused number one was bitten by a snake, my lord. And only to give the anti-venom injection,
No, son of.
son of accused number.
The informant claims to have been bitten by a dog.
Yes, ma'am.
Then he went there and this thing
Yes,
happened.
Thereafter,
This unfortunate peculiar incident happened.
Yes, madam. Accused number one son, aged about 4 years, my lord.
Uh,
He was bitten by a snake, madam, and only to give the anti-venom vaccine, he was busy with doctors at inside the hospital. According of the accused number one,
Mhm.
was involved in the fight of with the informant actually.
Over what? Man? This cannot be reason, This. If this is the reason, then they are mistaken in their mind, isn't it? Mistaken. So these two persons are the two persons named in FIR.
Yes, ma'am.
Jasim Ali, I see. He's son of, no, they're brothers, so
Yes, no brothers, madam.
not brothers,
It's a family member.
family members.
Accused number two was a student. He was
That's right.
originally belonged to Tamulpur, but he was staying at Borbata. He was doing some real course, madam.
So anyway, so what does the investigation say? Is the incident like this or it's something else?
their statement, injured statement, my lord, state is also available. They implicated that this is the incident.
Hmm.
Otherwise, my lord, injury report is not exactly available. One assessment report of the casualty assessment report of Bhitias Talukdar informant, my lord, advice admission, but patient partly refused. So ultimately,
Let me see.
and one CT scan report of the both the persons, my lord, informant and the injured is available. No such abnormality during CT scan. Only injury report is not there. One notice.
Laceration, stitches given. Yeah, I see.
Patient
Stitches.
refused, my lord, admission.
Yes,
of the-
Let me see.
Statement of the. injured-
Statement, this handwriting is
Yes, my
slightly
lord.
problem.
Statement of
Can
the-
you read one of them or
Yes,
just
I have.
tell me the substance?
Yes. Statement of the injured Dipankar Talukdar and other witnesses is also there, man.
You just one or two, you just tell me,
Yes,
gist.
yes.
Just. You heard so and so, 483 bail application. Seeking bail for Nasiruddin and Jasim Ali, arrested on 6/11/2025 in connection with Patsala PS case number 94 of 25 under section so and so. Start. The the case arose out of a fire dated 2/11/2025 lodged by one Dhiritiraj Talukdar with the allegation that on 1st November at night he was bitten by a dog, whereupon he went to the hospital along with his friend slash neighbor Dipankar Talukdar. And first, when they reached the hospital, some persons, upon seeing them, shouted that they should be killed, whereupon the shouting persons will attain heaven. And thereafter, all of them attacked the informant and his friend without any provocation. It is alleged that one of the attackers hit the informant on his head with a rod and tried to attack him with a knife. And another of them kicked him on his face and private parts. He named the assailants as Jasim Ali and Nasiruddin and given 2 mobile numbers as well. He stated about getting stitches on his head and stuff. Yes, tell me.
Yes,
Case
my
diary
lord.
has been received.
My lord, statement of the, my lord, informant and injured Dipankar Talukdar statement is also available, my lord.
Mhm.
And Dipankar Talukdar also, my lord, in their statement named these two accused persons, my lord.
Mhm.
Nasimuddin and. my lord,
And nature of the incident same.
nature of the incident, they, my lord, explain in the same.
Then why they assaulted, any provocation,
Assaulted
nothing?
actually, my lord,
Or is
that
it something else?
both the parties, they are, my lord, went there to, my lord, for treatment of the, one of the son of the, my lord,
Ah.
of the other opposite party is
Hmm.
also because of the snake bite there
Hmm.
at that point of time.
Hmm.
At that point, because large gathering was also there, maybe my lord, or not, I do not know.
But this peculiar aspect, is it there in the investigation?
Peculiar aspect, my lord, otherwise witnesses stated in that manner. Dipankar Talukdar and the informant.
On
both
that manner.
In that manner, all are friends, my lord. They were there at that point.
The investigation, it is submitted that the informant slash victim has supported the allegations of the FIR in his statement recorded by police during investigation. I perused the one medical document which indicates laceration and stitches. Full stop. Full stop. It is submitted that the witnesses have also implicated. So what should we do? Should we,
Considering that, my lord.
this kind of things should not be done, then.
Yes.
This should not be done. Anyway, the accused persons are in custody since 6/11/2025. The investigation has progressed to some extent. The given circumstances, I am of the considered view that
Only on the ground of length of detention.
they can be given bail, subject however to suitable conditions. Number one, sorry, accordingly, they are allowed to go on 30,000 with one security, like amount to the satisfaction of the concerned learned court. This will be Bojali, CJM Bojali, and subject to the following condition. Number one, they shall cooperate with remaining investigation, not hamper or tamper with evidence, not violate, not threaten, harass, or harm the informant or other witnesses. Number four, they shall not misuse their liberty to commit any illegal activities, and they shall also not commit any act which is prejudicial to social and communal harmony. Let it be. Stop. Violation of the bail conditions might entail cancellation of the bail. Return back to SRE. Please tell them also. I don't know what is this is the incidents. These are ignorant people who have not understood religion at all.
May I please, your lordship, this is a bail application under 483. My lord, before going to the FIR, my lord, I would like to bring, my lordship, may kindly come to page number 24, my lord.
Here, my lord, one SI Ranjan Soikia was injured, but his injury report is not available in the case.
Yes, ma'am.
Lordship, may kindly come to page
Yeah,
number-
which page should I see?
24, page number 24.
24.
Well, this is the AS memo.
Okay.
Well, there is no signature, counter signature of the accused person. There is no signature of any witness. Even there is no mention of any section, under which section I have been arrested.
And 47 notice?
24,
Notice.
as we under section 36.
47 notice is a little elaborate. Let us see. Arrested of public nuisance in an intoxicated condition. The grounds are sufficient. The grounds are sufficient. But signature, arresting officer, signature of the person. People. Officer, arrested person. All signatures are here on the thing. But arrest memo, there's no signature.
No signature, no, there is
Why?
no counter signature, no witness signature, even no mention of any section,
Why?
under which section I have been arrested.
No, grounds are there. Grounds have been given, sections have been given in the grounds. That's okay. That'll okay. But signature should be here. Should be here. Signature. Diary has been received.
Yes,
Yes, he was arrested on
I left the 211.
2/11. He allegedly assaulted one SI with a dove.
one SI, my lord.
Does it reflect medical report?
Medical report, my lord,
There-
not yet. received.
No, even in the forwarding report also, there is no mention of any medical report. Actually, it's a false FIR.
What is the, can we read the FIR once?
Okay.
I can read.
Base
You can read
schema
it.
inspection, base schema.
This 20. The inspection menu, yes, no,
Base schema to.
yes, 24. Also, may I read the FIR?
Yes, yes, please.
I, Sri Pankaj Sitala, LMPS, do hereby lodge this written complaint to report the commission of cognizable offense on so and so in at Uttar Ganga PS Helm at 7:30 has a telephonic information received from Srimati Purnima Bora, phone number so and so, reported that Vinod Bora, son of Babuli Bora, so and so, was illegally selling sulai and in a highly intoxicated condition was creating public nuisance by shouting abusive and filthy language, threatening villagers and disturbing the ongoing Bhavana Akhara near his house, thereby disrupting public peace and tranquility in the locality. Upon receipt of information, a GD&T number so and so was made, and I, along with SI Ranjan Soika and staff of 12 APBN, proceed in a government vehicle at 7:35 hours and reached the spot at 7:45 hours. On arrival, several plastic containers containing approximately 18 liters of suspected sulai were found, stored in the courtyard of the accused house, clearly intending for illegal sale. While I was conducting inquiry and seizing the contraband, the accused Vinod Bora to obstruct the police party suddenly emerged from behind armed with a sharp dagger and attempted to assault me on my head with intent to kill. I managed to dodge the blow, but he pushed me due to which I received injuries to my arms. He continued abusing me in filthy language and forcibly tore off my police nameplate from my uniform. When SI Ranjan Soika intervened to protect me, the accused again swung the dao with full force and struck Ranjan Soika on his forehead with the wooden handle of the dao, causing severe head injury and dizziness and immediate loss of consciousness. I immediately overpowered and apprehended the accused on the spot despite his violent resistance and continued abuse. SI Ranjan Soika was rushed to SKBCS, Sohit Kanakutta Bora Civil Hospital, Gopur, and later referred to Biswanath Medical College.
I've read it.
Well, there is no medical report.
But he's,
No, well, this is a false FIR. Actually, the fact is that
I'll just, what is the fact according to your instruction? Actual fact?
Actual fact is that, my lord, on 1/11/2025 at about 8 p.m. without any warrant or any court order or any case against me, the police team has entered into my house, whereas my wife and my minor daughter was sleeping at her bed. Then I see that actually I did not recognize that they are police person. Then I asked them why you are entering to my house, and without any police women police constable, they entered to my home. That is the actual fact, my lord.
So you registered and this.
No, my lord, I did not do this. That I asked the officer that why you entered. That is.
This,
Actually, this FIR has been lost by the
assault
police
by
officer.
Dow is false.
No, my lord, that is false. My lord, this FIR has been lost just to satisfy the ego of the OC LMPS. Nothing else, my lord.
LM is in which district?
My lord, in the Biswanath district. My lord. There's no medical report.
Two requisitions sent for getting the injury report, but the injury report not yet received.
There is no injury
Yes,
report. Since the next day, the officer has been in the.
I'll see that, just let's take it forward a little bit, heard.
For
Mr. Handik,
Handy.
I'm Handik, additional, I'll see the 483 bail application. Seeking Vinod Bora, arrested on 2/11/25, Helm PS case number, so and so, within bracket Biswanath district, under section so and so. The case arose out of an FIR dated 2/11/25, lost by SI Pankaj Sitala. Full stop. The gist of the allegations is that on 110, the
no,
No, my lord, what will you?
when did the incident took place? 110/25,
My lord,
111. They typed it wrongly, I think.
my lord.
Typed it wrongly. No, you have written in the top. They've written 2/11, but inside 110 is written. On the day of the incident, they got an information that the prison accused, after being intoxicated, was creating public nuisance. And therefore, upon information, GD entry number 12 was made, and thereafter the informant along with SI Ranjan Soikia and other staff reached the spot and found plastic containers containing 18 liters of suspected sulai in the courtyard of the accused for illegal sale. And so it is further alleged that while inquiry was being conducted regarding the same, the accused emerged with a dao in his hand and assaulted Ranjan Soikia, causing head injuries. Full stop. The learned petitioner counsel submits that the allegations in the FIR are concocted and false. It is submitted that the real story is that the police personnel entered his house and went to the bedroom where his wife and minor child was sleeping, and that he asked them as to why he had come without accompanied by women police personnel. The case diary, however, has been received. Yes,
Yeah.
now you tell me.
Now, my lord, as per the note of the IO, requisition sent to
Two
them for
requisitions.
my lord getting the injury report.
Injury report has not yet been received, despite two requisitions by the IO. Otherwise, the investigation is indicating which side.
I assaulted the my
Yes.
lord, one SI.
Injury report would have been helpful,
Yes.
drawing attention to the notice under section 36 BNSS within bracket arrest memo. The learned petitioner counsel submits that the accused signature is there, but witness is not there.
No, my lord.
No,
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 36
36 is also not there.
36 is there, I think.
24, page number 24, accused signature is also not there.
My lord, not there.
My lord, in the
No, inspection memo is there.
inspection memo, there is also, my
36,
lord,
yeah.
that case number is wrong, that date of inspection is
There's
also
no
wrong.
signature of the accused and witness as required in terms of the statutory provision and the law laid down by the Honorable Supreme Court in the case of DK Basu, the state citation to Likhit. So it is submitted by the learned additional PP that there are some, the investigation has revealed some adverse materials against the petitioner. In the given facts and circumstances, considering the length of detention and some progress in investigation, and also keeping in mind the projected deficiency in the notice under 36 BNSS dash I deem it fit to grant bail to the accused at this stage. Accordingly, allowed to go on bail of 30,000 with one security like amount, subject to the satisfaction of CJM Bishwanath.
My lord, SDGM Gopur.
Oh, yes, SDGM Gopur, number one. Subject to the conditions, number one, he shall cooperate with remaining investigation, not hamper or temporary evidence. Number two, not indulge in any activities pertaining to illegal liquor. Number four, he shall otherwise cooperate with the process of law. Violation might entail cancellation of the bail, return back is there. Allow his mention.
Number 5,
Interim order is there. Interim order is there.
Yes. Electrification. I am on interim person to your lordship order with the 25 line.
Yes.
Case diary was called for.
Here they received, my lord. He appeared statement recorded. No?
My lord, FIR, your lordship will find at page number 14, the relevant portion is at page number 70. It is an allegation regarding misappropriation of fund. Now, your lordship will kindly appreciate the fact that in the FIR itself, there are various contradictions. And my
you-
contention in the.
You can read the FIR.
My-
You can read the FIR.
My
You
lord,
can
it has been
refer-
lodged by one of the authorities of a concerned real estate firm.
Mhm.
I so-and-so, having office of so-and-so, engaged in the business of construction under the name and style of so-and-so. On 8/8/2025, I withdrew a sum of rupees 25 lakhs from the bank account of the firm for making labor payments. Out of the said amount, I kept 22,50,000 in a locked stroller. I'll lay emphasis on this words, locked stroller. Due to ongoing construction activities at the office, I deemed it fit to send the stroller through firm's driver at around 8:39 p.m. and keep the said stroller in the night of 18/8/2025 at the nearest house of an employee named so-and-so is the petitioner herein. The said stroller was received by so-and-so himself, and he was assured that the stroller shall be sent back to the firm's office next morning. In the morning of 19/8/2025, without duly informing, Mr. So-and-so called the HR and suddenly informed that he shall remain absent on 19/8/2025 as he is traveling to Nalbari, Assam. Upon receiving this information immediately, driver was sent to get the stroller back to the office in order to ensure the safety of the same. At around 5 p.m. on 19/8/2025, stroller reached the office and it was found that an amount of rupees 17,50,000 is short. Mr. So-and-so was immediately called, wherein he informed that he is in Nalbari, Assam, and he shall reach the office in the evening of 19/8/2025. On inquiry, he refused of having knowledge of the short money in the stroller. Further, after the said incident, the conduct of Mr. So-and-so has been evasive. Upon inquiry, his responses have been unsatisfactory and inconsistent. We also have strong suspicion that he did not actually travel to Nalbari as claimed, but instead was engaged in managing and concealing the stolen money. His behavior clearly raises grave doubts regarding the involvement of the theft. I therefore request you to kindly register an FIR against so-and-so and investigate the matter, take legal action against him. Now, this is the story projected in the FIR number. My contention in the petition that I have raised on instruction is, he was an executive in the concerned real estate firm, and he came to know about certain illegalities which were being committed by the people at the helm of affairs of the concerned firm, and he expressed his dissent against those. Now, he became the eyesore for the people at the helm of affairs of the company, pursuant to which this FIR was lodged, and it was lodged on 21/8/2025. Just 5 days after he has been terminated from service, I have enforced the termination letter at page number 13.
Yes, now I remember, but it's pending for a long time, should be
Yes, yes.
disposed of.
My lord.
So anyway, I remember now.
My lord.
Okay.
Now,
Yeah, the per se, the monetary amount is on the higher side.
it is a huge amount,
It doesn't- huge
but
amount.
the contradiction.
What is the, yes, I'm recollecting now.
My
What is this termination notice at?
The termination letter your lordship will find at
Yes,
page
I
number
found it.
13,
Found it.
dated 26/8/2025, which is 5 days after the lodging of the FIR. Now, here in this termination letter, there is no mention of any lodging of FIR. There is no mention of the incident as such. It is only that the reason that has been stated here for terminating him is pilferage and breach of trust. There is no mention of that very incident at all in this termination letter, which is 5 days after the FIR. That is one thing. And in the FIR, your lordship will kindly see there are certain aspects. For instance, my lord, at the first instance, the statement that has been made is that this amount was kept in a locked stroller. This 22,50,000, this amount was kept in a locked stroller, which was handed over to the petitioner in his house to keep it overnight because there was construction going on in the firm's office. Now, when eventually the stroller was taken back, it is not alleged anywhere in the FIR that the stroller was found in a broken condition. The lock was not, it is not an allegation that the lock of the stroller was broken. So if the stroller was under lock and key, if it was a locked stroller that was handed over to the petitioner, then taking back the stroller in a locked condition could not have, my lord, facilitated there being a shortfall of 70,50,000 at the first instance.
Anyway, so let us come to you. I'll come to you.
He appeared, my lord, his statement recorded.
True.
The petitioner, my lord, appeared before the, my lord,
True.
his statement recorded.
Right.
And my lord, from the contents, my lord, from the materials, my lord, from the case diary, I have found that till now he is a strong suspect, but till now there is no material that he is the person involved in, my lord, stealing all this amount of
Huge amount of money.
money, because yes, my.
There are no materials so far.
Till now, my lord, I do not.
Then his story might be correct.
Yes, yes, your lordship may kindly present, my lord.
No, I submitted. Take time.
Because otherwise, he is a strong suspect, because the, my lord, that stroller was in a lock and key condition.
The money has not been recovered.
Money, my lord, not yet recovered.
Hmm.
So till now, investigation is still going on. It
What
cannot
will be done
said-
then?
It cannot be said that this accused person is not at all involved.
Suspicions is there, but no concrete materials.
Yeah, till now, my lord, investigation is going on in that
Hmm.
regard, man. But till now, I do not.
So should we keep it, but it's pending for a long time. I don't want to keep it pending, actually.
Otherwise, his custody also, my lord, will not also help the unit.
Perhaps. Anyway. লিখে দিও, actually.
Because
This is property, first paragraph is 25/9/25 order. First two paragraphs are same.
admitted fact is that that stolen amount not yet.
Yes, yes. The case arose out of an FIR dated. What does he say in the statement? His statement, 21, the Zahar dated 21/8/2025. Lost by one Mohini Rai, representing the one company, Badri Rai and Company. Representing one firm, Badri Rai and Company, with the allegations that an amount of 25 lakhs was taken out for labor payments and kept at a certain place, but subsequently 17.5 lakhs was found short, and around the same time the petitioner was also found to be evasive. But how does he explain being evasive?
My lord, that entire fact is, my lord, he denied the entire fact. He stated that, my lord, nobody has kept any money in my house. On the next day. my
Money
lord,
has also not been recovered.
in his house. After taking, my lord, leave on the
Now,
next.
what
day-
are the specific materials against him? Can you tell me?
Against him, my lord, till now
Nothing.
only suspect evidence of the witnesses, those are the employees of the, my lord, one of the employee, my lord, he stated that yes, that bag was kept in, total amount is 25 lakh.
Hmm.
And with 25 lakhs withdrawn from the bank,
Hmm.
and among thereafter 22.50 lakhs were kept in a stroller, locked stroller.
Hmm.
Thereafter, my lord, it was, my lord, in view of the construction work that was kept in the house of the present petitioner as per the allegation.
Hmm.
And the statement of the witnesses also stated. Thereafter, on the next day, when that, my lord, money was taken back along, there, it is also not the, my lord, not stated that.
Only the co-employees have implicated.
Co-employees implicated that yes, that bag was kept in the house of Montu Das, and thereafter when taken back, that 17.50 lakhs were, my lord, at that point of time.
They submitted that, just give me once.
Yes, you know.
That investigation is continuing, has progressed, but it's still continuing. The statements of some co-employees are of an implicating nature in as much as they've stated that the amount of rupees 25 lakhs was in a stroller was kept in the house of the petitioner instead.
This is accused statement, and
Hmm.
before that, my lord, statement of witnesses.
The pursuant to grant of interim, he has appeared before the IO and his statement has been recorded where he has denied the allegations. Full stop. Somehow I'm not convinced. Not very convinced about this. Because how does he, shortfall is not, how did the shortfall happen then? If all the employees have ganged together against him, then of course,
Yes,
then he
otherwise,
will
my
be
lord,
inside without.
one thing is that, my lord, that driver was also, my lord, went there to take back that money, my lord, in
Hmm.
between there.
Mhm.
And my learned friend has rightly pointed out that there is no allegation regarding any broken, my lord, stroller or
Hmm.
any, my lord, regarding that allegation. While already in lock and key, how that amount can be, my lord, taken away from that, my lord, locked store?
Hmm.
That is also one aspect.
It's true. They submitted that the investigation so far has not revealed any materials of breakage of stroller, etc. Full stop. How many statements of witnesses are there? I'm seeing critically because of the nature of the incident, but somehow it's like
There's two employees, my lord, one
Two em-
user of the.
Both have been implicated.
Yes, both my lord stated that. That after my lord keeping those that stroller in the house of the present petitioner, thereafter my lord that amount was found short, my lord. That is the.
Mm. His mobile phone was also found to be switched off.
Next. Some suspect maybe involved, but till now, my lord,
Yeah, that's true.
it cannot be.
I think at this stage not be right to give. Let us see is what is still. There is an endorsement in the case diary about his mobile being switched off. Found to be switched off during the investigation. Full stop. At the time, around the time, yeah, after the incident. Let's go. Stop. The learned additional PP fairly submits that though though the investigation so far has revealed limited adverse materials against the petitioner, but the needle of suspicion continues to be directed at him. Full stop. In view of the nature of the materials and the nature of the allegations, I'm of the considered view that it may not be prudent to continue the interim anticipatory bail. Accordingly, the interim bail stands vacated and the bail petition stands rejected at this stage. Return back the case diary.
Obliged.
Let the investigation be done.
Right.
That's, we don't know.
Obliged.
Next.
Seven.
Seven. Yes,
Yes, may I please find out?
Darius come.
Yes, my lord. The prayer for my lord is PS bail application. This bail application, this present petition is second innings of life, my lord.
Mm.
This prayer for bail, my lord.
Mm.
Now, my lord, this present petition is a senior citizen, my lord, age about 72 years.
See, my lord.
Just a minute. An assault case, right?
Yes, my lord.
Mm.
The as per FIR allegation, my lord. The grievous hurt, my lord.
Okay. Looks not really.
Page 13, may I read this FIR, my lord?
Yeah, I've gone through already. I went through quickly. He was two persons, in the victim's husband, so a victim's wife.
Yes. my lord.
With a
Lost
dove and
his
so on, so on, so on.
Yes, my lord.
Time to person Rupnath Milis. Why, any reason why this is alleged? Do they have some earlier relation or something?
Yes, my lord, I think this earlier.
No. Let us get the case diary then if it is not received.
Yes.
We'll get the case diary.
May I please, my lord? Now,
Yes.
this present petitioner is the senior citizen. I have annexed this 11 number page, my lord.
Hmm.
The Annex 2.
Oh.
This is the certified by issued by this senior citizen, deputy commissioner, my lord.
Hmm.
This page 11A.
Mhm.
And now, my lord, the another page 12, it's a president, my lord. The
Hmm.
senior citizen is the president, my lord.
Hmm.
And now, my lord, page 21, it's the medical health issue, your lordship.
Hmm.
The page 12, my lord. And now, my lord, onwards, 23 is this present petition is the photograph, my lord.
Hmm.
Now he is in treatment,
Hmm.
medical, my lord.
Hmm.
And now, page 24, it's a chest pain, my lord.
Hmm.
All I have this annex, my lord.
Mhm. Okay.
X-ray report.
So I don't know whether allegations are serious anyway. The case diary is not yet received. Issue fresh requisition for the same. The learned petitioner counsel seeks some protection to record the statement of the petitioner full stop. Contending further that he is a senior citizen. And in this regard draws my attention to the annexed documents. Full stop. The allegations are about assault upon the husband of the informant by the petitioner and another who are named in the FIR. Full stop. Nevertheless, giving the petitioner an opportunity to record his version of events. It is in the interim, it is directed that in the event of his arrest, 25,000 baht security. Number one, shall cooperate in investigation. He will appear before the IO, make himself available for examination. And he shall not harass, harm, or intimidate the informant and her family members in any manner. This is the matter on
My lord, 7/1/26.
7-1.
1.
Deep level, my lord.
Item number 8,
Please, your lordship. As per the last order, the complaint was directed to furnish notice through paper publication, which has been duly served on 11th.
Just for leave petition.
Yeah.
You're in a complaint case.
Complaint.
Have you gone from the brief? So complaint case. NI Act case.
NI.
It's acquittal. Acquitting respond number 2 from Snow. Accordingly, you published in 2 newspapers,
Yes, your lord.
already done. Yes, right. It's you file an affidavit.
Okay.
Yeah, Assam Tribune is very expensive.
Yeah.
True. Space is very expensive there. So Assam Tribune has not been published.
Not some it is published in Dainik Assam and the Notice Time.
Okay. Notice times. Sentinel also needs, its cost is a little less. The Tribune is very costly, no doubt about that, but spaces, but still sometimes it is widest publication, widest very wide publication. Where have you stated about this notice stamps? Okay.
Notice Time and this,
In the affidavit? Not stated.
like we have filed 2 affidavits.
Oh.
Also. The second one we have filed, it was according to order 30 from this court. It was 30/10/2025. According to that order, we have filed.
Can you show me which page? And the second affidavit is regarding notice stamps.
Yes, sir.
Not, can you show me the page number? Help me with the page number. Your file, no, it's in the record. It's in the record. Sorry.
Recently, we have filed the.
Huh?
Recently, we have-
It's okay, fine. Should be here. I think. What to test. I must have missed. It was pretty silent. Assam Tribune has notice stamps so that I can reflect the paragraph also. Mr. Ray, CS,
Manavjyoti Hazarika,
M. Hazarika,
MJ Hazarika.
MJ Hazarika, Learned Council. In terms of earlier order of this court, the petitioner who's invoking the leave jurisdiction of this court to file an appeal against acquittal in a check bouncing matter, was allowed to resort to substituted service by way of newspaper publication in 2 dailies,
With all
Dash-
respect, I would like to.
Assamese and English.
Actually, not, page 14, paragraph 6 and 7, they actually filed this petition for, my lord, to waive the obligation to publish the legal notice in the Assam.
Assam Tribune, that's what I read.
Oh, yes.
Notice stamps? No. Notice stamps? Notice stamps you have not published.
Yeah, publish your.
Published, but that is not in the record. So what should we do?
I'm just pointing out.
No, no, yeah, I've read that.
Oh, yeah.
So should they file and he has submitted that they filed an affidavit regarding publication in notice times also.
Yes,
But we are not finding here.
yes, and I have also not.
It has not come probably. Can you show me this? Yeah. Maybe we can requisition. No problem. That is, I'll allow, that will do. The petitioner has filed an affidavit of compliance stating that though it has been published in Dainik Assam, but due to high cost vis-a-vis the value of the check. What is the value of the check? If you are, sorry, maybe you may not be able to say from memory. 14,000. 14,000. Only 14,000. Work out a settlement. It's already been, he's been acquitted, right? Okay. Nothing can be done about it. Then we have to see. Last vote to be given. High cost. Vis-a-vis the value of the check. It has not yet been published in Assam Tribune, and in this context, the leave applicant seeks permission of this court to. No, it is not again. You have actually, you should have taken the permission. In this context, it is submitted that the leave applicant has published the other notice in Notice Times newspaper and praised for acceptance of the same. Actually, it was not as per the court's order. Anyway, in support of the same, but it does not come. This affidavit we'll have to get on record. Let us get it on record and I can pass the order. I'll accept it, no issues. ... No, go ahead. It's not, this is the main affidavit. This is the main affidavit. No, this is the first affidavit. We'll get it on record. Then only we can. Sometime. Next.
Item number 9.
We have filed this IF for suspension of sentence, lordship. However, convicted the appellant lordship for a period of 10 years. and
Under
fined
section
376.
376.
Basically, we have on 3 grounds we have filed this lordship, IA. The victim girl is deaf and dumb, lordship.
Victim is deaf and dumb.
Her statement was reported by her distant relative, lordship, who participated in the investigation as well as deposed in favor of the lordship, victim lordship, as a PW3. And
The state has filed an objection.
yes, lordship, already filed objections, and lordship, medical report is totally silent about and that was not considered by the learned trial court lordship on the ground that lordship, that was done after 3 days. Even lordship, human was found to have intact lordship. No external injury, no internal injury. And FIR was filed lordship after 2 days of the occurrence lordship, and the reasons of delay not at all mentioned in the FIR lordship. This is the major 3 grounds lordship.
I was thinking, Bhattakur, that, just, because these kind of information is necessary. Sentence is also on the higher side. You are for the informant? You are for the informant, okay, good. Notice has been issued to the informant.
Yes.
And what is your submission per se? You make your submissions. Your good name, please.
Tiwa Pangla.
You can make your submissions. Then I will just discuss something with the prosecution.
The ground that they have taken is that the
You have filed a written reply?
no. Yes, the ground that the appellant has taken here is that
Notes. That's notes.
Okay, carry on.
ground that the appellant has taken here is that the interpreter during the trial was a relative of the of the victim. So the interpretation may not be taken into consideration. That is the ground they have taken. Your submission is that it should be interpreter should be a special educator. My submission here is that the victim, the PW3 is the relative of the victim. And since they are relative and since childhood they are close and relative, she knows what sign language he used. Sign language, the statement may not be interpreted by a special educator because the one who is relative and who is close to the victim, they know the every sign, every language that she wanted to interpret in the way she is comfortable or she knows the sign. So the ground that they have taken cannot be taken into consideration. Another thing is that the human is intact as per the medical examination. That is a submission by the intact human cannot be a factor that like there was not like rape was not happened. There is not a single whisper in the petition that like the accused, the appellant, had denied that he had not went to the victim's place in absence of
Are you in a position to tell me the approximate age of the victim?
My lord,
18 to 19.
Just if you're in a position to say, that's what I'm saying. She is not a minor, but and what is the age of the accused?
Accused is
Appellant.
36.
36 years. At the time of the incident, the victim,
yes.
victim was aged how much?
18 to 19.
18 to 19 years. Anyway, carry on.
and then regarding the presence of spread whatever they're submitting is that it was since the incident was reported after 2 days, so the particular presence may not be sperm may not be present at the time of examination because it was after 2 days of the incident will happen. And regarding the human intact, the submission made by the learned counsel for the appellant may not be taken into consideration because intact human men cannot be said like there was rape was not happen or it does not occur. The question here is the appellant, the accused went to the particular place in place of a victim where her parents no one was in the house, in the family, and then she was all alone in the house. So we can't be like come to a conclusion that like nothing had happened because they have not denied that like he have not went there or he have not visited the place in absence of the family member.
Okay. So I think yes, I'll yeah, you want to reply?
Relying on the judgment, lordship, this is judgment is clear, lordship. We have kindly see the place.
Which judgment?
So far, my learned friend is Lordship stated that Lordship, if any relatives interpreted the signs and symbols of the Lordship on the victim lady, that is not Lordship, kindly say, para 21, Lordship, of my husband.
And apart from, is there
Para
any,
21.
or is there any evidence apart from that, the victim's statement? Other evidence? Hmm.
Seven witnesses,
Hmm.
that interpreter, my lord, his statement is PW.
Anyway, para 21, I'll see.
Lordship, sir.
No, before proceeding further, because that's what I wanted to discuss with you.
Yes, my lord.
Should we, this is just an idea I was thinking. Should we request the registry to place for the court the number of criminal appeals pending for hearing? Then we know what is the number of this in the queue.
Your lordship can always.
Yes. And I want to just discuss with you.
Otherwise.
Because don't you think that's an important information?
Yes, yes.
What
yes.
is the number
Otherwise
in
we
this
will-
queue? Just, it has a 25 appeal. Right. But at the same time, see, even in that Gosai case, which says that there should be liberal interpretation
Yes. my lord.
of this thing, it
Yes.
has said unless there are some special circumstances. But in this case, I'm not, this prima facie, I'm not prejudging, but prima facie, there are some special circumstances in the sense that the victim is supposed to be, he's a handicapped person, challenged person, a very, very vulnerable person, very vulnerable.
Lordship has rightly pointed out that, my lord.
And I always ask this age because this is a very relevant factor in my opinion. Whether what kind of whether it is some out of relationship or out of it's more in the nature of assault. To throw light on this, the age is a relevant factor to some extent. Anyway, so this is what I was thinking. In that case, we'll not go fully,
Lordship can always ask for that.
We can ask,
information.
but I will allow
Otherwise,
you
my
to
lord,
just have your say.
some of
21
the-
we'll see.
Some of the cases,
Lordship.
very old pending cases are yet, my lord.
Lordship, kindly see the 21.
But for the moment, we can wait
Yes,
and
yes.
see how it. No. For the moment, instead of straight away giving bail
Yes.
because of special circumstances,
Yes,
we
yes.
can wait for some time
Yes. yes.
and then perhaps see.
And my lord, in this case.
That can be one view. Saying in this, but 21, let us read it. This is
Yes,
an
sir.
important principle actually.
Yes, sir.
To sum up,
To sum up, a deaf and dumb person is a competent witness. If in the opinion of the court, oath can be administered to him or her, it should be done. Such a witness, if able to read and write, it is desirable to record his statement, giving him questions in writing and seeking answers in writing, Lordship. Here in this case, Lordship, victim used to go in normal school. He can read and write, Lordship, also.
okay. She's studying also.
Yes, Lordship. Sir, Lordship, kindly see.
No,
In my appeal, Lordship.
No, I'm not disposing of today, so we'll go into it. We'll go into it. We'll get this data from registry.
Lordship,
And this statement is, according to you, vitiates. In case the interpreter is provided.
Lordship, see,
Last
the
sentence.
Lordship, victim can write and read.
So that was not done.
That is not done. And Lordship, only see, if in case the interpreter is provided, he should be a person of the same surrounding, but should not have any interest in the case. But here is a relative, Lordship. He participated in the investigation, deposed in favor of the Lordship victim. That person may not be
Interested
considered.
witness, actually,
He
see,
participated in the investigation
Yes,
also, Lordship.
partition witness is it is barred. But interested witness is that yes, close relative of a victim will be interested in conviction,
Yes.
in prosecution, but not necessarily false implication. Conviction, yes. If the relative thinks that crime has been committed, the relative will be interested in seeing that the guilty is punished,
Yes, Lordship.
but not necessarily false implication. If the witness is partisan, that he, irrespective of whether he is committed or not, he wants this person to be convicted, then he is partisan.
Yes.
So the line of distinction can be blurred sometimes.
Lordship, kindly.
Only because.
Now, para
Any
23.
judgments also on this, but this is a thing which is in his favor, no doubt.
Lordship, kindly see.
That she should be administered oath and she should not have any interest in the case.
Yes, Lordship.
Anyway,
Whereas he pointed out, my lord, he is a.
In evidence, it is clear, Lordship.
she is not a
Right.
relative, not a relative.
PW3 herself stated that she is a
Yes.
relative.
The-
Kindly see the evidence of the PW3.
If-
There are 23 may be seen that. Be that as may, her statement had been recorded with the help of her father as an interpreter. para 23. Who, for the reasons given by the High Court, being an interested witness, who had assisted during the trial, investigation, and was examined without administering oath, made the evidence unreliable.
No, if in that case, there may be there may be difficulty in basing a conviction solely on the basis of the prosecutrix.
Yes, sir.
As we know, it can be based on the sole testimony of prosecutrix,
Yes.
provided
Yes.
it is reliable.
Yes.
So this fact situation, this kind of fact situation could be could come in the way of the witness, the testimony of the victim being solely relied upon. But that's why I asked this question. We have not gone into the. Now it is not necessary to go that if there are corroboration,
Yes.
then it can save the prosecution
Yes,
case.
sir, corroboration is there, my lord, and he is
And
now
more
pointing out that he
particularly,
is
Lordship,
always related, he is a relative, my lord, that is the
the
interpreter.
appellant
Whether,
could not get a proper opportunity to cross-examine the victim girl. It is one of the factor, Lordship.
Okay, we'll see that. We'll see that.
Cross-examination is another part, Lordship.
We'll
He
see
could not
that.
properly.
We'll
And
see
now,
that.
Lordship, kindly see the in
We'll
appeal
go
note-
into some merits in this case on the next
Lord-
occasion because the nature of the case.
Lordship, kindly see the for a moment, Lordship. Page 49 of my memo of appeal, Lordship. Kindly see that. Page
But
40.
I don't want to go much deeper because
in all cases,
because
in-
I'm not keen to keep it parted, this one.
yes, in all cases,
For
my lord,
page
state
49.
interpreter itself, my lord, there are decisions of the state interpreter in all cases is not at all mandatory. If, my lord, otherwise, my lord, she can communicate and the interpreter can, my lord, clearly understand.
You look up some case laws also.
These are, yes,
Do
those
some
are-
study, do some homework. It will help you in other cases also. Yeah, please. Page
49 and relevant portion
49.
49 of my memo of appeal, Lordship, not in IA. Page 50, Lordship.
Mm.
Lordship, kindly see in middle portion, Heyman.
49.
It was found intact, Lordship. Heyman. And last part, Lordship, last 6 lines from bottom, injury on the body not present. Evidence of struggle and evidence of state not detected. Mental condition at the time of examination normal. Other is normal, Lordship. Now, Lordship,
We have
next
to
page
we'll see
51.
very carefully later on.
No, Lordship. Page 51, opinion part, Lordship, kindly. Opinion part.
164 statement.
Yes,
Yes, I've seen the opinion parties. I've seen
Opinion
that.
part, first, Lordship, kindly see that. Opinion, Roman 1, no evidence of recent sexual intercourse detected on her person. No evidence of injury detected on her person. She is above 18 to 19 years. No injury, no external either internal injury, Lordship.
No, we have to see
Not-
the reasoning of the court also, why the court thought that. is-
After 3 days of the incident, my lord, that's.
We'll see.
After 3 days
We'll
of the
see.
incident, my lord.
Okay.
medical
Court
examination.
interpretation is para 30, Lordship. Page 73. Para 30, page 73, Lordship.
Yeah, anyway, let us not go deeper because I'm not keeping it parted. We'll call for that report. List. Heard, so and so learned counsel, I. Criminal appeal, what order has to be placed? It is it has been admitted, right?
Yes.
It has been admitted already. Actually, the criminal appeal is also ready for hearing.
Yes,
The
Lordship.
record has come
Yes, Lordship.
and this he is also appeared. So we can also hear it. Not today, not today, but we can get this data. This data will be helpful in other cases also. So we'll get this data. The appeal, this instant criminal appeal has already been admitted. By order dated 7/2/2025. And the TCR has also been received. Full stop. The informant as respondent number 2 was noticed. And he has entered appearance to learned counsel. Your good name, please. Full stop. The learned counsel for the petitioners, for the applicant seeks to point out some contradictions and infirmities in the prosecution case containing further that the conviction is bad in law and facts. The prosecution has filed a written objection and supports the impugned judgment. The learned counsel for the informant also submits informant / victim side also supports the impugned judgment and contends that there are no infirmities therein. It is during the course of hearing transpired that the victim was supposedly a challenged person. Was a deaf and dumb person, was a challenged person by way of disabilities in the area of hearing and speaking. Let's stop. The learned registry is requested to kindly place before this court a data regarding the total number of single bench criminal appeals pending, so as to determine how the present appeal registered in 2025 stands in the said queue. Full stop. This is also necessary for the purpose of adjudicating such interlocutory application seeking suspension of sentence. Full stop. Itu IA order to IA order. It will mix up again. IA order to hold. IA order submissions will be in the IA. It appears that the criminal appeal is also ready for hearing, so we can hear it. Let us get this data, then we'll hear it. If I cannot get bail, then we will try to hear it.
We'll fix it.
But it will be allowing the matter to jump the queue.
Yes, yes.
That is also a problem.
Lordship, so far, Lordship,
It
interlocutory
should come
application is
up with-
concerned, Lordship. It may be hard at any time, Lordship.
Oh, yeah, yes, it's
Main appeal is concerned, Lordship, it will come chronologically.
actually, we can fix a date in here, but that will not be very fair unless there is something very urgent. Because it will be like jumping the queue. Yes, he's a challenged person. That is one
Yes.
factor. That reason can be given, but otherwise it will amount to jumping the queue. That will not be fair. That is why let us get this data. We all need this data. It is there. It may be available on the website. I don't know. So can I keep this judgment? We'll hear. Don't worry. We'll hear. All these things have to be
From
heard.
last 11
properly.
11 months he behind the bar,
The
Lordship,
reason-
and during investigation also
Like-
it was
like-
5 months, Lordship.
So it is the learned counsel for the applicant submits that after the judgment, he's been in custody for 11 months. And earlier, he also underwent under trial detention for 5 months. We'll look into it without delay. Don't worry. Whatever it is, I'll look into it. Now when should I fix it?
On 8th of January, 8/1.
Hmm?
8/1,
8/1.
8/1.
Is it okay for you? After a month? When would you like to? You suggest me a date.
For vacation, anything.
Before vacation.
For vacation, anything. Anything.
Let us get the data. They may be able to produce the data.
17/12.
Okay.
7th.
No, let it be on 18.
18/12.
18/12. এটু ঠিক করেছিল না?
Captain,
এটু ঠিক করেছিল না? এটু অডিও ঠিক করেছিল না? অডিওটা ঠিক করেছিল না? অডিওটা অলপ চাইছিল না? ইনক্রিজ করে দিছে। পড়া দিছে। Okay.
This IS, I'm not pressing on this IA lordship.
Okay. You want to withdraw it?
No, that IA lordship.
Mhm.
I'm not pressing on that IA lordship. That's quite ineffectual.
What is it about? What is it about?
This although I am appearing lordship, I have mentioned for
I'll-
listing,
I'll have a.
this engaged council is not
Right, not the date of listing. 11, 11 to 2. This is already passed. It has already passed. The date has already passed.
yes, lordship. That is why it has become.
It has
infrastructure.
infrastructure.
Actually, yeah.
It is submitted, your good name,
As circle lordship.
as Sarkar Learned Council
If-
submits that the present interlocutory application has become infructuous. I perused the prayer portion of the petition. The instant interlocutory application is disposed of as infructuous.
Lordship, in the
What
main,
is the main matter?
lordship, the contacted council is not available today due to some personal
You want
difficulty.
another date?
And seeking for a thought accommodation. lordship. Although it regarding addition of 307 in the charge sheet, lordship, that's what it is.
Yeah, but since there is an order of stay, it will get delayed, so do it next day.
At the
We
earliest
can
date, lordship.
dispose it off.
Lordship.
Learned Council seeks an accommodation today due to some difficulties of the leading council. Full stop. The prayer is allowed, but as there is an order of stay, the endeavor would be made to conduct a hearing expeditiously. Full stop. This is the matter. After 2 weeks, we'll give
Lordship,
it.
can the order of extension of interim order be reflected? Because
Yes,
that
yes, it has to be.
Code below has.
It has to be.
Lordship.
The interim order dated 15/9/25 stands extended till the next date of listing. It has to be allowed,
Fine.
extended.
Actually, basically, there is a confusion regarding that
Yes.
trial court is being seeking.
Yes, so it is
15, 12 months.
no, let it come after
Okay,
vacation.
after-
Lordship.
We dispose it after vacation.
Yes,
Uh,
on
You prepare it, there's enough time.
19th of
you
January,
do it.
19 one,
After Bihu.
after we,
Can be before Bihu also.
before we on.
After Bihu, 19/1.
I'll apply
19/1.
that.
You prepare, you can do it.
Lordship.
You do it.
19 one.
चाहिए part है डेले पास है Mr.
Yes, my lord.
I just
My lord,
I think I'm glad. I think we can hear your matter today.
Yes.
I had a short list due to some personal constraints, but we are almost done. So we'll hear this. So I'm just walking out. We have only 3 matters left now.
Okay.
The probably one will come. I think production list. No? We allowed one correction matter. I think. So bail part heard, bail hearing, and you'll be arguing it yourself.
Yes.
yes, my lord. I have already placed my argument, but it was long days ago. So, my lord, just to refresh your lordship's.
Just a
my
minute.
lord,
Not this
I-
matter. No, not sorry. I'm interacting with another petitioner in person. I'll just come to you. You have a seat then. You have a seat. Have a seat. We have 2 matters. Okay. Mhm. Bail 2. Okay. Which word council is ready for item 2? Item 2, you were there. Why was it part heard?
Your lordship heard at length, my lord. And my lord was pleased to, my lord, direct to, my lord, call the, my lord, there is the city on that occasion, my lord, not available with us. Along with the, my lord, there is a sketch map. And my lord, there is one, my lord, order which reflects that the present accused petitioner, who is now, my lord, arrested in case of one of, my lord, that is the West Bengal police registered case, my lord. So, my lord, that is on, because, my lord, NDPS matter, so our query is that on which matter he is arrested, whether he is a, my lord, habitual offender, my lord, involved in, my lord, NDPS cases or not, my lord. My lord, we received the, my lord, CD, my lord, but, my lord, I didn't notice the, my lord, that is the sketch map, my lord. But 2 times I have done through that, my lord. It may not be available, my lord. And regarding other part, my lord, that is regarding the, my lord, status of the, my lord, that is the case where he is arrested, my lord, in, my lord, that is the West Bengal, my lord. That, my lord, was not available with us, my lord. That, my lord, regarding notice. But, my lord, in the, my lord, that is in the order sheet, in order dated 10/11/2025, my lord. I have flagged my there, my lord. As per that order, my lord, he was, my lord, in, my lord, Coast Bihar, my lord, jail, Coast Bihar jail, my lord. And, my lord, the next date was fixed on 21/11/25, my lord. Though, my lord, that order was not available.
In Coach Bihar court.
Coast Bihar, my lord, in Coast Bihar, my lord, but detail was not sent, my lord. So, my lord, at this stage, my lord, can my lord one prayer may be made, my lord? Yes,
Mhm.
because my lord, it is my lord, that is from the central jail of Kasar, my lord. Central jail of Kasar, my lord. My lord, he was my lord sent to my lord, that is Coach Bihar, my lord.
Mhm.
So whether my lord a direction may be sent to the my lord, that is the superintendent of my lord the Kasar jail, then that will be easier. He can give us the all details
Regarding?
regarding that another case where he is
Oh,
arrested in.
yeah, they have
Yes, my
details. They will
Madam,
have
may
details.
kindly peruse the order that 10-11-25, my lord. 10-11-25 order C. My lord, there is a new record, my lord. I have flag marked
10-11.
10-11, my lord. I have flag marked, my lord. That is a 10-11, my lord.
18-11 is there. Then 16-10.
No, my lord, in the
Both are my orders.
no, my lord, in the my lord, there is a record, my lord.
Actually,
What
it's a
record?
16-11, my lord.
In the record, my lord.
Acha, acha.
One 10-11 order is there, my lord.
You have marked flag.
Yes.
Mhm. Yes. This one.
Yes. As part that, my lord, at that point of time, he was in my lord. This is the custody of my lord in Coach Bihar, my lord.
Mhm. At present, he is not in Kasar.
He is not in Kasar, my lord.
Mm.
Even my lord, though my lord, 21-11-25 was the last date, my lord.
Mm.
That order is not with us,
Mm.
but my lord, in virtually we checked it, my lord.
Mm.
As per that order also, my lord, he is in my lord, Coach Bihar, my lord.
Mhm.
So, my lord, if my lord, a direction is sent to the my lord superintendent of jail, my lord, that is
It's
my
Central Jail, Kasar, Central Jail.
yes, my
Central
lord,
Jail, Kachar.
central jail.
Yeah, let's do that.
Yes.
But learned Mr. T. S. Sek, Learned Counsel, and K. Boyson. Full stop. Voluminous TCR has been received earlier. You did not notice the sketch map.
Sketch map, my lord. I think.
But should we requisition that, or this is a bigger issue? This
My
is a
lord,
bit-
here only the thing is that, my lord.
Anyway, it's
My
okay.
lord, this person, my lord, who is arrested, my lord.
Mm.
Their contention is that he was on at that point of time present in the house of the co-accused, from whose house, my lord,
It was
that is the contraband
contraband
recovered.
seized.
That is their contention.
Mhm.
Now, my lord, during the courses, because my lord, it was take the lead, police take the lead of the my lord another co-accused,
Mm.
who identify the another co-accused
Mm.
from whose residence, my lord, this is the 2 cylinders,
Mm.
1 lakhs, my lord, GABA tablets were my lord recovered. But my lord, at that point of time, local COTs were called, my lord. Local COTs, my lord, stated that the house is not the house of the another co-accused, but it is the house of the present accused petitioner. This is one point, my lord. Secondly, from the interrogation in the my lord, that is the statement of the co-accused, that is the Taramoni, from the lead, my lord, Taramoni was identified. And as per the my lord, there is the investigation. The raid was in the house of Taramoni.
Mm.
So Taramoni said that along with this person, my lord, they did the things, my lord, because the cylinder was, my lord, it was, my lord, concealed in the house of the present accused
Anyways,
petitioner.
now remembering also.
And my lord, that is the in the note, my lord, which is available in the CD. There, my lord, police stated that they stated, my lord. From that part also, my lord. Maybe, my lord, there may be a case, my lord. But
We
my
have
lord,
to see the this 37, right? In this
yes,
case.
my lord.
Merits. We have to see
On-
merits.
Yes, my lord. On that point, my lord.
It appears that the accused UTP is presently in Coach Bihar jail.
My lord.
Coach Bihar jail.
My lord, there is
With regard to other cases pending against him in the state of West Bengal. In this connection, allowing the prayer of the prosecution in this regard, and which is also agreed to by the learned petitioner counsel, which is also fairly agreed to by the learned counsel for the petitioner side, the learned superintendent of Central Jail, Kasar Silchar, shall submit a report regarding the other cases,
my lord, regarding his, my lord, that is where he is sent to, my lord.
whereabouts.
Whereabout.
Uh,
The
the
detail
pres-
of the case along with
the,
the, my
the
lord,
details of the other cases and his present location.
present location.
Mm.
My lord, that is a detail, the case details is mainly required.
Yes. Details of the case and his.
It is another case, my lord, we have nothing
My
to
lord,
do with that, my lord.
Just whether jail superintendent has available with the case details, my lord.
No, they
Since
usually
all the
have.
My lord,
all the
UTP is,
No, they have. Other
They have.
cases they have record because they have to go on allowing on bail. Suppose the one case is there, they have said this is bail.
yes, my lord.
They keep track.
Yes.
Manually they kept, but
Yes.
keep track, but it should be computerized.
Yeah.
Like, they partly it's computerized, but not so much, as
But
far as I know.
Date may be fixed, my lord. Prior to that, I think important.
List the matter on. You can search
Prior to vacation.
18, 17. 18, 17.
A copy of this order may be provided, my lord.
Yes, a copy of this order shall be furnished,
15th, my lord.
furnished to the prosecution and also sent to the learned superintendent. No, you will send
No, we will
Ah,
send, my.
to
we
the,
will send,
to the prosecution for the needful,
My,
for information and needful.
my lord.
List the matter on 1812.
18.
What is this? Just let me see. 11 item number 11. Yeah, this is,
That is a lordship.
which was, why is the part hard? What to matter? This 11. Item 11.
In this matter for the respondent number 2, Rajsekhar sir is appearing
Hmm.
out of station.
Up station. Okay, I'll just come to that. Don't worry. We'll see.
My lord, they are
I had heard it in
for
part.
several occasions, my lord. Yes, my lord.
I'm having some notes here.
I put the case on.
You are appearing
where,
online
my
from?
lord, They are taking agenda.
Just a minute. You are appearing online.
And
from-
last occasion, my lord,
Where are you appearing from?
from my lord, Agartala,
Huh? Agartala.
Agartala, my lord.
Okay. Yes, I'm
Agartala.
remembering. Yes,
Agartala.
remembering. Yes. You're seeking cancellation of bail.
My lord.
Cancellation of bail.
He obtained fraudulent.
Okay,
Yes,
I see.
my lord.
Hmm.
My lord, may I kindly see his bail petition, my lord.
Just let me, just a minute. Let me see the
He
previous.
has
application.
last 49,000.
How much we have
Hold on,
progressed?
my lord.
Just wait, hold on. Just wait. Respond number 2. Don't. You have filed the affidavit, right?
Yes.
That's a pleading complete. Form is not been submitted. Notes to, how come I don't have the notes here? That's notes to payroll license should have been here. Notes to payroll license. Notes license. Hearing person extensive. Right? So would you like to conclude your submissions today? Complete remaining and conclude, Mr. Lord?
My lord. On last occasion, my lord, I have concluded my argument.
Would you like
And
to?
they sought for time. And
Yes, yes.
thereafter also, last
Yes,
day
yes.
also they sought for time. And this
Okay,
occasion
you have,
also,
you have concluded.
my lord, I have, my lord, I filed this bail application, my lord, 1 years back. 6/11/2024, and they are dragging this matter.
No,
On
we'll resolve
15th
it. We'll
On
dispose it.
15th July, my lord, this court, my lord, said that this is the last chance. 15/7, my lord, kindly see.
1811. 14/9. So this is positive time. So they filed. So I think it's very.
My lord, may I kindly see how many occasions they sought for time.
Final form has been submitted in the meantime.
I think PP may say, I think no, my lord. But my only one submission is they obtained the bail order fraudulently, misleading the court.
You complete your you just refresh your submissions quickly.
My
You know,
lord,
and then we'll he's seeking a date. We can give a date, but on the next date you do it or we'll proceed, right? Anyway, so you refresh your submissions, but the audio from your side
or
is
on the next
slightly.
day, or on the next day, my lord, I should refresh your lordship. Otherwise, my lord, if
Okay.
after 5 or 7 days, your lordship, then my lord, your lordship may forget, subject to
Okay.
approval of your lordship, my lord. Or I
Mr.
have no objection, I can refresh it today itself.
No, that will be better. It will be that is always better. When the other side is taking notes and all. Otherwise, he's also capable, so he will take notes and you have to brief his senior. So it's better that leading counsel is also present. So on the next day, as you said rightly, on the next day when he is present, we'll complete both sides, right? Have you heard me?
Yes, my lord.
Uh,
Any date as suitable
yes.
by my
Great,
learned
great.
friend.
Mhm.
I may come or I may
Mhm.
join it through
The,
BC.
Mr. S. Lord, learned counsel, appears through online mode from Agartala, full stop. The learned counsel had uh, addressed arguments earlier on this matter. The learned counsel for respondent number 2 seeks some time due to the stated personal difficulties of the leading counsel R. Rajshekhar. Full stop. In this context, the petitioner counsel has submitted that the matter has been pending for some time. Upon perusing the record, I find force in the said contention. Endeavor, the learned counsels on both the sides shall assist the court in expeditiously disposing of this matter. Full stop. The matter is being kept as part heard so far, as per order dated. When so 7/8/2025. You can suggest me a date. You can suggest me a date.
My lord, I do not have any objection. Any date I may either may come or through BC, my lord, I shall appear.
You want to
As
come
the lordship
today?
deems fit.
Or you can do it from there. But today
My
I'm
lord.
having it's like we'd have had to
My lord, my lord,
adjust.
my lord, my lord.
If
Any
we-
date.
If you had taken the hearing today, I would have sought some adjustment in because
No,
audio
no,
is
no, my
a
lord.
little less.
As the lordship's convenience, my lord.
That's not a problem. No, not my convenience also. Your and both sides' convenience also as well.
My
Prosecution.
learned friends, the dates which learned friend suits, my lord.
You would prefer before vacation, I think, probably.
Yes, my lord, definitely, my lord. Before vacation, my lord.
Possible after vacation.
No,
My
let
lord, it is
pending for a long
2024
time.
matter of
These
bail
matters
cancellation
should not
matter.
be in the docket for long,
Okay, Lord.
right?
My lord, here one more submission is here that my lord, CDs remains here for last
Long
until
time.
27/7. my lord.
That's not fair. That is not fair. That's the problem. So he's seeking bail cancellation on materials which are already stated to be available here. So
My
it should be in the meantime you can send and get back. I'm thinking of fixing it on
Just reopening, my lord.
reopening.
My lord, in this year, my lord, prior to vacation, my lord, any date.
Otherwise, my lord, in the last week, my lord, it will be motion days, my lord. And all the motion matters will come, my lord.
Only possible date before vacation seems to be 12th.
My
I
lord,
can fix it on 12th.
my lord, 12th.
My lord.
After 10 days, that is. But the CD will not be updated in
My
10
lord,
days.
this is-
12 I can fix.
My
12
lord,
I can fix. If you
my lord.
let it be on 12.
my lord.
We'll try. Hale. Yes, come. Good. এইটো হেৰিয়ে লিখিছিল নেকি ৰাখি লিখিছিল the leave applicant has also filed another affidavit stating about publication of the same of the notice in the English Daily Northeast Times and prays for acceptance of the same. I allow the prayers. I peruse the affidavit and the paper notices. Full stop. Paper notices. It was published on which date?
11/11. 11 November 2025.
Both the Dainik Asam was on
The same day.
same day, and Northeast Times was same day.
Not this.
Both the paper notices were stated to have been published on 11/11/2025. Today is, yes. Sufficient time has elapsed. However, none has appeared on behalf of the respondent number 2,
2 and 3.
2 and 3, were the accused in the NI Act proceeding leading to their acquittal. why notice was not possible? Because they are not. Huh? Huh?
Like the address, where the postal town we have tried 2 or 3
Because
times.
this is a Bhangagor address, Christian Bosti, isn't it? Anup Nath. It's not there. Nobody is there.
Nobody.
Nobody is there.
Nobody.
Megua construction. I know. So should we go into the merits? Prosecution has a limited role. I think. Would you like to submit on merits? Why this leave should be allowed? Leave to file the appeal against acquittal. Leave has to be granted, right? We can also do this. Let me see. You are also capable. I'll just have a look.
Well, NIA case.
This leave petition is of 2016. How come?
They're not, the opposite party are not appearing. Market transaction at one hour.
The instant application, the instant proceeding arose out of an application under section 378(4) of the CRPC, seeking special leave as statutorily required to prefer an appeal against judgment and order dated. Judgment and order dated. You help me with that. 4/8/2016 passed by the learned JMFC Kamrup M in CR number 2468 superscript C 2010, whereby the respondent number 2 and 3 as accused were acquitted. Full stop. What are the grounds here?
Board of directors, there's a signature of board of directors. On that, the judgment was passed.
It is stated and submitted that after initial deposition, the accused persons were summoned, and during the trial, the complainant side examined one witness. And there was no defense evidence. It is contended that that the magistrate had proper jurisdiction to adjudicate criminal litigation and conduct the trial. Full stop. No. It is all, and that the accused were also sufficiently represented during such trial. It is also contended in para 8 of the leave petition that the shifting of the burden of proof to the to the complainant at one stage of the trial by the learned trial court was erroneous. And they're erroneous, leading to infirmity in the order of equitable. Upon perusing the materials and hearing the learned counsel, your good name, please. I'll allow the leave.
MJ Hazarika.
MJ Hazari. Full stop. Dash, Radiba. Invoking the powers under section 378(4) CRPC as it existed then within brackets. The lead petitioner, MS Gupta Hardware Private Limited, represented by its manager Manav Lokar, is hereby granted the leave to prefer the aforementioned appeal against Egutel. The instant leave petition stands allowed and disposed of on aforesaid terms. The main criminal appeal, it's come up also. Main criminal appeal has also come up.
Yes, Your Worship.
Only filing number is there. The criminal appeal may be registered and put up for admission. Again, you face this issue. They'll have to be noticed. You try again, you try to ascertain their proper location. Then in two alternative places, two places, you can send a notice.
Yes, sir. It's okay.
Necessarily pending. No problem.
I cannot help.
Yes.
Good afternoon, sir.
So it's all, you have the matters are done. Mm.
Thank you very much, sir, for
No
giving me this opportunity.
No issues. Yeah, since you are appearing as petitioner in person,
Yes, sir.
you can address the court in any comfortable mode,
Yes.
no issues.
Yes.
No issues.
Sir, I'm Dr. N. Rajamarthandan IPS, sir.
Yes.
Presently, I'm serving as Senior Superintendent of Police, FRRO Barpeta, sir.
Okay.
Foreigners Regional Registration Officer, Barpeta. My headquarters is Barpeta. I'm coming from Barpeta for appearing before the Honorable Court. This criminal revision petition has been filed before this Honorable Court, seeking for setting aside Section 217 of IPC, read with 98 Assam Police Act, upheld by the impugned order of the Honorable Additional District and Sessions Court, Kamrup, sir, from an obviously a typographical error in a secondary document, not from the primary document, and also seeking for quashing of the entire criminal proceedings, which is unlawful inter alia as per Section 23 of the Right to Information Act, sir. And today I am standing before this Honorable Court charged under Section 217 of IPC, which is a non-cognizable section, and the maximum punishment is up to 2 years of imprisonment, sir. For this, the police had investigated the case for 5 years and 9 months, and subsequently the courts have extended it, and totally 8.5 years. This criminal process is going on, sir, which is an indication for
Yes.
this Honorable Court about
Yes,
the
yes.
vexatious and
IPC.
seditious nature of this prosecution, sir. With that proposition, sir, I initiate my argument from my
Just,
side.
yes. No, that's okay. Prosecution, just one thing I just like to, because the revision before the additional sessions court was filed by you, right?
Yes, sir.
But this is a revision, you have invoked the provisions of, no, if necessary, you correct it, if necessary. That's why at the outset, we should just, go into this issue. 442 of the BNSS, right? This is pertaining to criminal revision. But don't you think you have to also invoke or only invoke the provisions of 528 also? Criminal quashing, because your prayer is quashing, because why I'm saying is because 442, let us see, look up. Okay, do you have the book or you want? We can give you a book. BNSS are deposit, use both sides. Yeah, you can take from here, no problem.
582.
442. Now we'll hear and finish your matter, and I mean, will not keep pending. High Court's power of revision. What was the earlier section? 401, I think, CRPC. Because what I'm saying is that if a party prefers revision before the sessions court, the same party cannot prefer a revision for the High Court. So the same party can come by invoking the quashing power in the 528 now, earlier 482. So the Bhattakur kindly look up that provision. Because if necessary, you correct it by filing a small additional affidavit. Because the jurisdiction, in any case, you are seeking quashing only. Just a minute. This is the problem. 443, 440 subsection 3. This is the problem for you. Unless we, amend it or something. You have the book, you can electronically, okay. Electronically also you can see. Section 440, subsection 3 of BNSS, right? You can see another book. Take out another book. We have plenty of books. 440. Take out another book, no issue. Bhattakur?
440 subsection 3.
Yes. So what is the way out then?
Already, you will have to amend.
Amend the petition
Yes.
or file an additional affidavit.
Yes.
So if he brings in for 528, that will I
Yes.
think safe.
Yes.
Because his prayer is in any case quashing.
Question.
I was saying your prayer is quashing only, right?
Otherwise,
So these are technicalities of law.
otherwise
Sometimes
heading
you
is my lord on
may not be
criminal
aware.
reason.
Huh?
You will have to come a criminal petition, my lord.
Criminal petition.
Petition.
Yes. Criminal petition.
Because here heading is criminal revision.
Revision,
But
yes.
otherwise, second revision, my lord.
That is the thing.
Yes, that is the
That is what I noticed, and that is what
Otherwise, my lord, initially, my lord, trial court has framed charge under section 218. But my lord, session judge has, my lord, altered the charge under from 218 to 217. So that aspect, one aspect is there. Whether under that circumstances, my lord, again, my lord, revision applicable or not, my lord, because session judge has altered the charge from 200.
No, not against charge revision applies.
Applied, yes.
It applies.
Applied.
So
Otherwise,
you
my
are
lord,
saying that will be a fresh.
same person, my lord, otherwise this is second revision.
No, otherwise, if that perspective is taken, then it's like an original order.
Yes.
That's what you're trying to say.
Yes.
Like an original order.
Original.
New charge.
Yes, new charge.
Otherwise, what is the way out? He has to amend or we suo moto can we take?
To directly file a criminal petition, my lord? These controversies will not arise, my lord. He can, my lord, then raise all these grounds. Otherwise, he tries to, my lord, project his case that this is because altered charge is section 217. On that ground, my lord, if this revision is maintainable, then you will have to point out.
Yeah.
this.
Because this can lead to complications later on. That's why
Yes.
initially if we resolve it, that's best. It's a technical thing. You are praying for quashing only. He's praying for quashing only. I'll come to that. Just a minute. But we'll resolve this. We'll adjudicate this matter. Don't worry. We'll decide this matter. Whichever way, that's of course none of us can say, but it will be decided. It will not keep pending. Quash the So should we, if he files an additional affidavit, will it solve the problem? Additional affidavit, invoking 528 and seeking conversion.
That he can do, otherwise, my lord, revision, it would be better than one amended petition,
Hmm?
criminal petition.
Amended petition.
Amended petition, that would be more convenient.
Would you like to file an amended petition? Invoking, because 480, invoking this 528 BNSS.
Inherent power.
When was this filed? May.
May.
This should have been correct anyway. We had not, the court had not gone into this earlier perhaps. It was heard, no, partly, but it's not part heard. There's an order of, I think. It was once heard, I think, partly. You introduce the matter and then you file an amended petition. I'll take it up, an amended petition. But it will not be possible to keep it as part heard because first the amended petition has to come.
Let him first file the amended petition, then otherwise.
File the amended petition then. Anyway. So you, since for your satisfaction, you introduce the matter. What is this? 217? We'll hear it afresh, but you introduce the matter. Since we have been waiting morning.
Otherwise, one difficulty for him only arise because the matter is already fixed for hearing. Now, if he file an amended petition, then matter will be again come up in the column of motion. Then it will again, then it is, my lord, because of this, my lord, he will have to file an.
Any private respondent is there? No.
No private respondent.
Then again, then it will not be much time. He'll file the amended petition and furnish copy to the prosecution.
Otherwise, prima facie, my lord, this petition is not maintainable.
Otherwise, it will create, even if we, it will be erroneous on our part to, not, because it's a technical, defect, technical defect. So once you correct it, there's no issue. That's best you correct it at the beginning instead of having complications later on. But anyway, what happened? Your revision was allowed doing away with 218.
Originally, the case is of Paltan Bazaar Police Station, case number 311/2017, sir. And the PRC is before the Honorable Additional Chief Judicial Magistrate, Kamrup Metro, sir. The trial of the case has been already stayed by this Honorable Guwahati High Court on 5th of May, sir, 2025. Originally, the case had two accused persons, sir. I am the accused number 1 and accused number 2, Mr. Ambika Roy, has been already acquitted during a criminal revision petition before the Honorable District Court, sir. Presently, I am the only accused person left behind in this case, sir. So on 10th of March 2017, sir, about 8.5 years before, the Assam Police Headquarters, that is the DGP office, constituted an SIT for the purpose of investigation of the Silapattar PS case of the Dhemaji district, sir. I was made as the head of the SIT. In the SIT order copy, I have placed it in page number 49, sir. That particular incident is related to a law and order incident that happened 4 days prior to the constitution of that SIT, sir. An incident in which there was no loss of life, not even practically a case of even simple injury was there. Of course, there was a damage to property was there. On 4th of April 2017, sir, about 26 days after the SIT took over the case and started the investigation, the then DIG of CID, Assam, suddenly lodged a complaint before the Guwahati City Police, sir, that is the Paltan Bazaar Police Station, alleging against me that myself, while serving as SSP CID, Special Superintendent of Police of CID Assam, and also the designated Public Information Officer of CID Assam, supplied a copy of the progress report of the Silapattar PS case of the Dhemaji district to accused number 2 upon an RTA application given by him in violation of law. This is the allegation in essence, sir. The FIR copy, I have placed it in page number 52, sir. The essential fact which I wish to draw the attention of the Honorable Court is, sir, that the document connected to the case has been identified in almost all the paragraph of the FIR by the complainant as the progress report of the Silapattar case of the Dhemaji district, sir. Sir, after investigating the case, sir, the Guwahati City Police took about 5 years and 9 months and finally submitted the charge sheet before the Honorable Additional Chief Judicial Magistrate. And there were 9 sections in the charge sheet, sir. Cheating, conspiracy, forgery, abetment of crime, official signature, all those things, sir. On 21st of May 2024, sir, last year, the Honorable Trial Court, after hearing the argument on charges, I am very thankful to the Honorable Trial Court. So, dropped all the 9 sections that were invoked in the charge sheet against me, sir. Actually, the story of the police ended in that particular day, sir. However, sir, the Honorable Court used the power and authority of the Honorable Court and invoked a new section against me. That is section 218 of IPC, read with 98A Assam Police Act. This section 218 of IPC was not there in the charge sheet before, sir. The charge framing order, I have placed it in page number 84, sir, for the kind notice of the Honorable Court. Not a single section from the charge sheet could figure in the charge framing order. A logical question anybody would ask is, what were the police doing for 5 years and 9 months that not a single section from the charge sheet could figure in the charge framing order, that the Honorable Court has to bring in a new section. Even that also, sir, did not have the mandatory prosecution sanction from the government of Assam, which is required, sir. So the charge framing order, sir, which I have placed it in page number 84 for the notice of the Honorable Court, sir, is the formal and the foundational order upon which a trial is initiated against an accused person. However, sir, there is another document, secondary document called the charge form. This is basically a synopsis and extract of the charge framing order, sir. That charge framing order, sir, I have placed it in page number 85. That also, sir, in the concluding paragraph is conveyed the same, that I am charged under section 218 of IPC, read with 98A Assam Police Act. There is no doubt about it. Unfortunately, sir, a typographical error crept in the charge form only, that secondary document. 4 lines from the below, sir, there was a vague and a non-cogent mention of 217 of IPC. 4 lines from the bottom.
Page?
Page 85, sir. Charge form only. If you read the charge form, sir, even
Page 85.
yes, sir. Even a schoolboy will say that it is a typographical error, because the heading itself says the charge is framed under 2 head. Only 2 paragraphs are there. The first paragraph is dedicated for section 218 of IPC, and the second paragraph is dedicated to 98A Assam Police Act. There is no other paragraph because the heading of the charge form itself says charge under 2 head only. The first head is 218 of IPC. The second paragraph, whose heading itself is given by the Honorable Court as secondly, and 98A Assam Police Act. That last concluding paragraph, which conveys clearly that charge under section 218 of IPC, read with 98A Assam Police Act, is framed against the accused and the accused person, and the contents of the same is read over and explained to him, and he is pleaded not guilty and claimed to be. So there is no difference between the charge framing order and the charge form except for the typographical error, sir. When the charge framing was challenged before the Honorable Additional District and Sessions Court, sir, the Honorable Court was pleased to set aside section 218 of IPC, sir. But, sir, picking up the typographical error in that secondary document, sir, the Honorable Court went on to say that it is upholding that 217 of IPC in the charge form, and also made a very vague and a shaky order of asking the trial court to make it clear. Very unusual and paradoxical and self-contradictory order, sir, where the Honorable Court is saying it is upholding something which the court in its own understanding and observation has said that it is unclear, and wanting the High Court, trial court to make it clear. How can the court uphold something which the court itself says that it is not clear?
Where is
not
that part of the order?
Yes, sir. Page number 46, sir.
Now, this is the order, right? 100,
improved
page
order
100,
is, 30.
100, page 100, right? Page 100. It's the revisional order. Instant revision is allowed. The impugn order is set aside.
Yes, sir.
Where charges have been framed is
Sir.
hereby set aside.
The improved order is from
Set
page
aside.
number 35 to 47, sir. And this paragraph I may be permitted to read, sir. Page number 46, paragraph 19, sir. After setting aside section this, the impugn order whereby charge under section 218 of IPC is framed against the petitioner is hereby set aside, and the charge for offence under section 217 of IPC that has been included in the charge form is upheld. However, the said charge 217 of IPC need to be specified clearly by the learned trial court. Same page and the first paragraph also, that is paragraph 17. However, I am of the view, the Honorable Court says that the learned trial court need to make the charge clear. So what the court itself said it is unclear, not so distinct, has been upheld. It is totally a paradoxical and hollow in meaning, sir. It is actually doesn't make any sense.
No, what is the difference? Which is this order? Page
Yes.
100, page 100.
Sir,
Page 100 is another page 100 and this one.
Sir, the page 100 is that acquittal order of that accused number 2, sir.
Oh, I see. Okay.
This-
Two,
this include order-
two, right? Oh, okay.
Page
Hmm.
46, that's the operative part.
Hmm.
46, the operative part, sir, paragraph 19.
Hmm.
For the benefit of the court, I am reading again, sir. The impugn order whereby the charge under section 218 of IPC is framed against the petitioner is hereby set aside, and the charge for offence under section 217 that has been included in the charge form is upheld. However, the said charge under section 217 of IPC need to be specified clearly by the learned.
No. And you are contending that
It is.
in the original, in the charge form, there's only one charge form. In the charge form, the form and manner, form in which 217 finds place is a typographical.
Yes, sir. Any number of times we can read this charge form in consonance with the charge framing order, which is the formal and the foundational order.
Yes.
217 is practically not existing. We cannot prejudicially and very unjust to exploit a typographical error and enlarge into a charge. That is very unfortunate, sir. It is like putting a knot after knot, and how can I keep on explaining and explaining again and again, because I explained everything before the Honorable Trial Court. That is why the Honorable Trial Court 217 was never ever in the mind of the Honorable Trial Court. It never included in the charge form. Again, it was resurrected using a typographical error. Unfortunately, during the hearing, if this question has been asked, I would have been pleased to explain that. I was not even asked about this. When the order came.
And charge sheet was filed under 218 section,
No, charge sheet was filed under 9 sections, sir.
including 218.
No, 218 was a new section brought in by the Honorable Court upon its own power and authority. And even that did not have the mandatory prosecution sanction from the government of Assam. But still happened because I came from Barpeta. I also missed that. But that framing of charges happened.
Prosecution sanction was not there.
Not there. But somehow I also missed, but framing a charges
Anyway,
trial also started.
Yeah, I've understood. Prima facie understood.
Yes, sir.
So what we'll do is that since, this is just technically, it is at this stage in the present form not maintainable. So we cannot really say that we heard. So best is you file a amended petition and then we'll take it up. When can you find the amended petition? Within a week?
Immediately I can.
No, as soon as possible you
As
file
soon
it. Because these matters should be adjudicated, whatever it is, as heard Dr. Rajanathan, learned counsel, the petitioner in person. Full stop. The petitioner is invoked the jurisdiction under section 440 BNSS agreed by order dated judgment and order dated 24/3/2025 passed by the learned additional session judge number 1 Kamrup M Guwahati. Whereby the charge frame against we won't say much so and so this also heard learned additional people. It appears that as let me see that section again. Ranjal, this Botago. Yes. This subsection 3, what was the exact language? Section 3, 440, where application for the submissions in this. Yes. As the revision before the learned session, additional session judge was at the instance of the present petitioner. Therefore, in terms of section 443, another revision would not be maintainable before this court. In this context, the petitioner in person submits that he would like to. What do you do then? Withdraw and file a amended petition.
One difficulty will again arise. Already the proceedings already state. In
Okay.
case of my lord, now in this the present revision petition, because at that point of time.
Then we can convert.
uh,
If he files an amended petition,
Conversion also, my lord, whether there is any such provision. for
Or
conversion.
convert into criminal petition. What will be the best course of action? Kindly guide.
Conversion is also, there is no such provision of converting criminal revision to criminal petition. my lord.
Mm.
Otherwise, my lord, at this point of time, my lord, only way is to file an amended petition.
Amended petition.
Amended petition,
And-
because
And upon amendment, what do we do?
among amendment also, my lord, stay order automatically stay will be vacated.
And yeah, amended petition is filed, then it is re-registered.
Yes, my lord, he will have, again, my lord, it will come as criminal petition as a new case, my lord.
Yes. Then we have to fast trace order.
Yes, yes.
Hmm.
First place order. Otherwise, at this point of time, already the matter also, my lord, stay order also will, my lord, go at the-
If the amended petition is filed, it will be,
Yes.
no, not
Then-
non-new petition. I mean, if amended petition is filed, it will be filed as a criminal petition. Sorry, it will be, then I also am saying that to register as a criminal petition, it has to be converted
Yes.
and re-registered. That's why I'm saying he withdraws this and files a fresh petition.
It would be better for him to withdraw, because otherwise there is no provision for conversion of. my lord,
Yes, that
criminal
is what
revision
I'm
to
thinking.
criminal. So he will have to withdraw and file a fresh petition, my lord. And at that point of time, he will have to place that already earlier in the criminal petition, at that fact was not pointed out, and because of that stay order is also,
Mm.
if he, my lord, made a statement regarding that, my lord,
Mm.
then automatically on the same day he
Now
will.
you quickly file a.
Stay order.
Since in the present form, the criminal revision would not be maintainable, therefore, the petitioner is given the full stop. The petitioner seeks liberty to withdraw the revision and file a fresh petition invoking 528 BNSS. 528 BNSS, full stop. The prayer is allowed. The instant revision petition is disposed of on withdrawal with the aforesaid liberty.
Yes.
Then what happens to the stay order?
Stay order, my lord, automatically.
Automatically it will vacate.
Vacate.
Then you file it quickly. Because again, we have to take a fresh call on that, right? We can pass an order. Consequent upon the aforesaid order, the interim order dated 5/5/25 will stand vacant. You file a fresh one. File a fresh one. When will you file? You file it. It's for your conference. Then it will come up and then we'll take a fresh call.
My lord, I have a,
Disposed of
my
on
lord, I have a small submission, my lord. Here in item number 6 regarding my lord.
6.
My lord, in this case, I have submitted that they have not appeared and statement not recorded, my lord, after entry. But here some of the noting of
They've
my lord,
appeared.
my lord, due to the mistake on our part, my lord. But from the case
They've
that
appeared.
appeared, my lord,
I
statement
think, did
recorded.
I say that? It was allowed or?
No, not allowed. And
This-
scan copy was called for. 2 CDs was
achha.
called for, my lord.
I
One
see.
charge sheet.
Oh, that one.
My lord, that one, my lord.
So I think I have not recorded that submission. If we have recorded, we'll delete it.
My lord.
কাটি দিব, কোনে বা কৈছে?
Not required for update, my lord, as they have.
Oh, not record.
Right.
Up to date scan copy is not
No,
necessary.
no, scan copy is required, but CD, both 2 CDs were called for, my lord. One CD we have received. I said that it was not up to date.
Mm.
And another charge sheet
Charge sheet.
completed. That scan copy already called for. In the present case, my lord, 193, my lord. Only one line, my lord, they have appeared, my lord. Statement also
okay.
recorded. That part,
Rest remains same. They have appeared. Due to scan copy call person.
scan copy already called
Yes,
for.
yes.
In the another case, 194 of 10.
No, I am disposed. Could I dispose? কিয় কাৰণে আছিলে এইটো? Pursuant to order dated so and so, passed in criminal revision petition so and so, the I becomes infractious and disposed of accordingly. Infractious.
No.
Okay, okay, okay. matter, correct? No problem. Sorry, it's 24, no, it should be.
Yes, sir.
That's all, no?
That's
all. Do just record law. The I has been filed for council. The I has been filed for seeking correction of seeking a correction in the order dated so and so 28/11/25 passed in BA 3803 of 2025. It is stated that instead of special PCM case number 9 of 25 to 9 of 24, it should be special PCM case number 9 of 25.
9 of 24, Lordship, instead of 9 of 25.
Oh, sorry. 9 of 25. Instead of a special PCM case number 9 of 25, to italics too, you give it in italics. It should be special PCM case number 9 of 24 in bold.
Yes.
The aforesaid error is a typographical error and is corrected, stands corrected. This order shall be read as part of the order dated 28/11/25, passed in BA 3830. I stands allowed in this poster. Okay.
Sorry, Lordship, for the inconvenience.
No. We are sorry. Actually, so it should be crept in. No, doesn't matter. Okay.